Hello and welcome to Spardha Lines, your one-stop destination for the civil services preparation, UPSC, KPSC and other relevant examinations. Today we picked up some of the important articles from the Hindu which are very significant from your UPSC and your KPSC examination point of view. Let's get started and look into the first article. The first article is important from your GS paper 1 perspective, which is about social issues. This can be very important on your tribal rights. It can be very important with respect to what are the empowerment programs that have been taken by the government of India to uplift the tribal sections in our country. So the government of India has initiated number of programs for the tribal heartland people, and one such program that the government of India has taken up is what is called as the PM Janman package. So in this discussion, what we will have is an elaborate discussion with respect to PM Janman package. What is this PM Janman package? Who is it intended for? This particular program is intended for the PVTGs. Who are the PVTGs? These are the particularly vulnerable tribal groups. What do we understand by particularly vulnerable tribal groups? They are defined by the government as tribal communities that show either a declining or a stagnant population, use of pre-agrarian technology, economic backwardness, low literacy, etc., so on and so forth. They are found to be living in some of the remotest and most inaccessible areas in the country. There are as many as 75 such communities which are spread over 18 states and union territories. All these pointers are very important from your preliminary examination point of view as well. UPSC in the year 2019 or 20 has asked a question about these PVTGs. So who are these PVTGs? These are nothing but the tribal people. Tribal people who are present in the forest areas. They have been living in the forest areas for a very long period of time. There are multiple tribal groups that are present. Why are these people classified as the particularly vulnerable tribal groups? There are hundreds, thousands of tribal groups that are present. Despite the existence of all these tribal groups, why are they classified as the particularly vulnerable tribal groups? That is because when you compare other tribal groups with these groups are particularly having a stagnant population. Their population is not increasing over a period of time, or in fact their numbers are also dwindling or even decreasing as well. That apart, when you consider the other tribal groups, they are able to empower themselves. They are also able to adapt themselves to the modern technology as well. They have been able to establish modern agricultural practices. But when you consider these tribal groups who are particularly vulnerable, they have not been able to adapt or acclimatize to the new areas of innovation and agricultural adaptability. So they are still sticking to the shifting cultivation, they are still sticking to the pre-agrarian technologies, and they also have relative economic backwardness as well. So if you juxtapose and you weigh equally, there are some groups who are economically prosperous compared to these people. There are some who are economically backward. They also have very low levels of education as well. Despite provisions, despite boosts, despite all the mechanisms that have been put in by the government, these people still show low educational levels, and that is the primary reason they are called as the particularly vulnerable tribal groups. So remember, we have the particularly vulnerable tribal groups who are the tribal groups, but in comparison to the other tribal groups, they are economically weaker, they are educationally weaker, and they do not possess the technology to empower themselves despite opportunities provided by the government. Where do these people live? These people live in the remote corners of the country, and these are the areas which are mostly inaccessible to the number of people in the country, which is why they do not have access to much of the facilities that have been given by the government. There are about 75 such communities which are spread over 18 states and union territories. In fact, similar such statement was also given in UPSC preliminary examination. So remember, there are 75 such communities which are spread over 18 states and union territories. As part of the exam, as part of the assignment, I have a question for you. Which state in India has the most number of PVTGs? So which state in India has the most number of particularly vulnerable tribal groups? Please put it on the comment section. Which state in India does not have this PVTGs? Put it on the comment section. Which state has most number of PVTGs? Which state does not have PVTGs is what you have to put on the comment section. And for the ones who answer this, I'll make an announcement as well, and at the same time I will give the information in tomorrow's session. So this is what you have to put on the comment section. So what has happened over a period of time? Over a period of time, the government has come to an understanding that despite the number of programs that have been taken by the government of India as well as by the respective states, these people are not able to reap the benefits of such schemes and programs. In order to empower them, in order to give boost to them, in order to ensure that those programs are ultimately reaching to the beneficiaries or to the people whom it is intended for, the government of India has come up with what is called as the PM Janman package. So this PM Janman package, is a program, is a policy initiative, is one of the agenda of the government of India to ensure that all the programs that have been envisaged for the tribal heartlands, especially for the PVTGs, are intending to reach those people who are generally in need of it. So as part of this particular package, what is that the government is looking at? The government is looking at providing pakka houses for these people, connecting roads, because these people are living in the remote corners of the country. They do not have infrastructure development that has taken place. So providing them the houses and providing these houses with the connectivity roads, and also providing pipe drinking water as well. We know for the fact that right to water is one of the fundamental rights guaranteed under Article 21 of the Indian Constitution. So providing them drinking water facilities, community water supply, mobile medical units with medicine costs, construction of the hostels for these people, occasional education and skilling, construction of the Anganwadi workers, construction of the multi-purpose centers, energization of the last mile connectivity, provision of solar off-grid system, solar lighting in the streets, setting up of VDVKs and installation of the mobile towers. These are the initiatives which will be taken as part of the PM Janman scheme. That apart, we will also have the Ministry of Ayush, which will also establish and set up Ayush Wellness Centers as part of the existing norms, and at the same time, the Ministry of Skill Development and Entrepreneurship will facilitate skill and occasional training in PVTG habitations, multi-purpose centers and hostels as per the suitable skills of these communities. All this will be taken up and will be catered to those sections who are in need of it. This is one part. That apart, we have multiple ministries which are into picture. These ministries also have a defined role that they play when it comes to the policy initiative. Let's say for example, we have the pipe water supply. We have one of the Ministry of Jal Shakti that comes into the picture. Or let's say for example, we have these hostels that have to be come into picture. So you have the Ministry of Social Justice that emanates. Then we speak about health related parameters. In that case, we have the Ministry of Health that steps into the picture. So the major fundamental problem with respect to implementing this particular program is that we have couple of ministries which are implementing a certain part of the program, but ultimately they also have different outcomes about this particular program. They have different viewpoints of this particular program. This happens to be a major challenge. So if at all there is a challenge with respect to the execution of the program, what is the challenge? The challenge happens to be how is this going to be implemented? What are the issues that are surfacing between different departments? What are the issues that are surfacing between different ministries? Because each ministry has its own personnel and an administrative setup which wants to work in an intended fashion which it has been designated for, but then there is no inter-ministry, inter-department coordination, and that happens to be a major obstacle and a challenge when it comes to these areas of activation. So the major problem is that this ministry, interdepartment, interministerial understanding, collaboration has to be enhanced. That is one. Added to it, whenever we are speaking about the PVTGs, what we require is the numbers. Numbers of what? A census, or that these many people are present in a particular area. These people will have to be provided so and so program. These are the people who are present who do not have the educational values. These are the people who are not being able to empower over a period of time. So these numbers have to be given. But unfortunately, we do not have the precise numbers. The sampling surveys have not been conducted as well. We do not have the actual numbers numbers and precision numbers as well. So this happens to be a major problem. So the major problem in all these cases is, one, we do not have inter-department and inter-ministry coordination, and at the same time we do not have precise numbers. And if at all this particular program is implemented, then what about the ecological imbalance? So if at all the infrastructure program has been developed and we have number of economical prosperous program or infrastructural program that comes up in a particular place, what about the ecological diversity? How are we going to manage the ecological diversity? How are we going to ensure that the ecology is not disturbed amidst the developmental prospects of this particular program? That also has to be taken up as part of this initiative. So this happens to be a program that has been initiated by the Government of India, basically to ensure that the PVTGs are empowered over a period of time and they would be able to lead a respectful life in their own area as well as in their environment. It is this that we have to understand with respect to this article. Now let's look into the next article. This article here is speaking about Article 370. In Article 370, we recently have discussed in an elaborate way. I have also put up the video on the channel as well, where I have discussed the latest verdict of the Supreme Court judgment. We have explained in detail how exactly the transition happened, what was the Supreme Court judgment, what did the Supreme Court ultimately conclude, what it did say about the Article 370 and temporary provision, what it spoke about the sovereignty principles. Everything has been explained in this 1 hour video. We will not be discussing about Article 370, but one of the viewpoints given by one of the judges, who happens to be Justice Sanjay Kishan Kaul, was with respect to the Truth and Reconciliation Commission. So it is in this particular backdrop we will try and understand what is this Truth and Reconciliation Commission all about, what is the purpose of appointing the Truth and Reconciliation Commission, what is the intention of coming up with it, what have been the examples from couple of countries world over, if at all it is adopted in India, what is the challenges that we are facing currently, and what is the way forward, is what we will try and understand everything about this Truth and Reconciliation Commission. We have discussed about Article 370 in number of classes of late. This Article 370 is basically one of those temporary provisions that was inserted into the Constitution of India under Part 21 of the Indian Constitution. This has been discussed. As part of this judgment, we have one of the justices who also went on to recommend that what we require is the Truth and the Reconciliation Commission. So he made a suggestion to the Government of India that, dear Government of India, you appoint a Truth and Reconciliation Commission. This Truth and Reconciliation Commission, if at all it is appointed, should be able to look into what has happened in the past in the state of Jammu and Kashmir, now a union territory of Jammu and Kashmir, the human right violations that have occurred, people who have been asked to leave that state because they have been living in that particular area for a very long period of time, but because of the human induced factors like the terrorist activities, like the fundamentalist factors, like the terrorist communities, like the communist fundamentalist ideologies, there have been some people who have been asked to vacate the state and now they are living a deplorable life. So in order to re-accommodate them, in order to understand what flight did they go through, in order to make sure that such human right violations does not occur in the real future, what we have to do is make an appointment in the form of Truth and Reconciliation Commission. So what will be this commission all about? This commission will basically look into the past issues. For example, if you take the state of Jammu and Kashmir, now a union territory, there have been number of incidents of fundamentalism, communal violence that has taken place. So the Kashmir Pandits, who were integral part of Jammu and Kashmir, were asked to leave Jammu and Kashmir and now they are living in some other states of India. And was it a voluntary movement of these Kashmir Pandits? No, it was because of the fundamentalist activities that have taken place by the non-state actors who infiltrated into the Kashmir Valley, and there was a lot of bloodshed that was involved. In fact, number of movies have also shown the same thing as well, that there was bloodshed, grave human right violations, there were rapes that were committed, and there were bloodbath that took place in the state of Jammu and Kashmir back then, and as a result of which these people were coerced, forced to leave the state of Jammu and Kashmir back then in the early 1990s. So this article precisely goes on to say that we have justice who has made this recommendation. So if at all the government of India is coming and appointing a Truth and Reconciliation Commission, how should it be done is what is this article all about. First, we have to understand the meaning of Truth and Reconciliation Commission. We have Priscilla B. Heiner. Who is she? She happens to be a human rights activist. She says that a Truth Commission is one which is focused on the past rather than on the ongoing event. So the first parameter of the Truth and Reconciliation Commission is that it focuses on the past. So there has been an incident that has occurred in the past. As for example, if you have to take the examples at the national level, in the state of Jammu and Kashmir, now a union territory, we have seen large scale human rights violations. So it's an incident that has occurred in the past. To understand what has happened in this particular state, to understand what are the human rights violations that have occurred. So we are going back to the past event. We will speak to the victims of that particular crime and ultimately get information, extract information so that such issues does not occur. So what is it about? It is about a past event. Investigate a pattern of events that took place over a period of time. So this particular incident or insurgency or human rights violations that took place in the state of Jammu and Kashmir happened for a specific period of time. So it might be for 1 year, it might be for 2 years, it might be for 5 years, it can be for a decade. So for that period of time, what were the incidents that occurred in that region will be collected by this Truth and Reconciliation Commission. And this commission engages directly and broadly with the affected population, gather information on their experience. So for example, there is an event, that is the Kashmir Pandits who are living in the state of Jammu and Kashmir moved to some other part of the country. We go speak to them. We ask them what is the trouble that they faced, what are the vicissitudes that they faced, were they allowed to actually live in that particular area, what is the flight of these people, what is the grief of these people, what did they undergo through. We sympathize with your cause and ultimately extract as much as information such that these incidents does not occur in the near future. We put in a law in place, law and order situation violation does not reoccur. So we seek their experience and ultimately that will be recorded as part of the Truth and Reconciliation Commission. It is a temporary body with the aim of concluding with a final report. So what they'll do is collect all the information, put it into a form of a report and ultimately give it to the government of India and is officially authorized or empowered by state under review. So it is state organized as well. Remember, when we speak about these commissions, it is not just appointed by the state. There have been examples in the past as well where NGOs have also ensured that there is Truth and Reconciliation Commission, which means NGOs have also appointed generally in an objective criterion. It is the state, which is the government, which has to appoint this Truth and Reconciliation Commission. But is it only the state which has done it? No, there are exceptions as well. There are NGOs which have actually started off with the Truth and Reconciliation Commission. There are also United Nations body as well. For example, truth commissions are known to have been appointed by United Nations such as Timor-Leste or East Timor, and a non-governmental organization such as World Council of Churches in Brazil as well. The International Center for Transitional Justice, an NGO established in March 2001 to propagate truth commissions and help to transfer expertise, is still working in many countries. So if at all we have to take examples, apart from the states, there have been NGOs, UN organizations which have also established this Truth and Reconciliation Commission, basically to understand what triggered that event, what happened with that incident, what are the human rights violations that were committed, speak to the victims of this particular crime, elicit their information and ultimately ensure that such incidences do not occur in the near future. If we have to take the example globally, Heiner reviewed Truth Commission from Uganda to Kenya. The two best known and most consequential commissions are considered to be one set up in South Africa, Australia and Canada. In India's neighborhood, truth commissions have also been set up in Sri Lanka as well as in Nepal. So these are some of the examples that we have world over. As the best example, what we are taking up is the example of South Africa. Why South Africa? In South Africa, we have had the apartheid movement. The white had their so-called white supremacy, and they did treat the blacks or a certain section of the people in that particular community in a deplorable manner, abysmally, in a poor taste, and there was racial discrimination as well. In order to understand what this apartheid movement was, how the discrimination was perpetuated to a certain race, what we had was the Truth and Reconciliation Commission, which was appointed in South Africa. So South Africa is the best example, says the author. So that is why the author takes into picture the South African example. In South Africa, the first post-apartheid government of President Nelson Mandela established a Truth and Reconciliation Commission in 1995 with the aim of uncovering the truth of human rights violations during the decades of apartheid and to heal the country and bring about reconciliation with its history. The TRS was focused on putting together information and evidence from both the victims and perpetrators of violence rather than on prosecution and punishment for crimes. The South African Commission had the power to grant amnesty in exchange for this full disclosure by applicants. What does this mean? So there was a commission that was appointed by South Africa, and they ultimately elicit all the information from both the perpetrators and victims of a particular crime, and they also had the right. So it is a commission. This particular commission had people from different ways of life. You had people from different walks of life. You had women. You also had men from different races as well, and ultimately they formed a commission. This commission also had the right to grant amnesty, which means to say that they would be given a particular remission, or for example pardoning of all that they have done in the past. Is this power, should this power be given to the state of Jammu and Kashmir? No, says the author. The author goes on to say that whenever we are appointing a commission with respect to Kashmir Valley or with respect to the state of Jammu and Kashmir, who will be part of the commission will have to be chosen properly after a lot of reading and understanding of that person, and subsequently what will be the objectives of this commission will have to be given properly as well. So if at all the government is conducting such a commission and is making an appointment, the terms and conditions for the state of Jammu and Kashmir should be given properly, now a union territory. And at the same time, selection of members of this commission should also be done in a right manner. So what does the article say? The article says the central government has denied permission in the past to prosecute certain members of the defense forces for alleged offences and right violations. When you consider the state of Jammu and Kashmir, from 1947, we have had issues in the state of Jammu and Kashmir, all because of the non-state actors. These non-state actors are from Pakistan, and they can also be homegrown terrorists as well. So these non-state actors as well as the homegrown terrorists, if at all they are given pardon, that will not serve the purpose, because from 1947 a lot of soldiers have sacrificed their life. If at all this amnesty program which is present in South Africa is adopted to India, that will not help, says the author. So the author goes on to say that the adoption of the South African model may be good, but at the same time not everything can be adopted, because you do have the non-state actors who infiltrated into the state of Jammu and Kashmir, now a union territory, and these people have put in a grave violations in this part, committed grave human right violations, and these people will have to be prosecuted, and amnesty to the non-state actors should not be given. And at the same time, the central government also has supported some soldiers who have been able to stand up for the rights of other people. They have put their body as their shield. So if at all they have committed human right violations in a bona fide way with the right intention, then such people should not be prosecuted, and as a result what these terms and conditions are, how prosecution should take place, should be clearly identified. The Supreme Court of India, in General Officer Commanding Army was CBI and another 2012, held that the government sanction is necessary if there is reasonable nexus between action and the lawful discharge of the duties of the official. It also mandates needs to be chosen carefully without having adverse impact on the overall credibility of the security forces, including the armed forces. So if at all the we are coming up with such a commission, we have to give clear-cut guidelines as to what the commission should do, and it should not hit the credibility of the security forces, says the author. So what is the way forward? It would be most useful in reconciliation and in building fractured societies. So if at all this commission is appointed, what we will have is certain terms and conditions which will be taken up, the truth will be elicited, and ultimately the report will be put out. So we would be able to rebuild the entire society, and we would be able to learn from our experience, and at the same time ensure that such incidents does not occur in the near future. And at the same time, for the incident that has occurred in the Jammu and Kashmir, what can be done? So the author goes on to say, what we can do is restitution. Restitution of what? That whatever has happened in the past, the same similar such activity should not occur in the near future, but before this activity had occurred, there would be people who would be living in that particular area. For example, the Kashmir Pandits, whatever wealth that they had, whatever properties that they had, whatever was the original way of living of these people, that should be restored to such Kashmir Pandits. Is it a possibility? The author says no, it may not be a possibility. So restitution may not be a possibility. So one of the ways as to how we can accommodate back these people back to the state of Jammu and Kashmir, now a union territory, is restitution. That is to give them the ways and means of living their life originally before these insurgencies occurred. Is it a possibility? No. So the second option is compensation. What is compensation? Damages. For example, paying through money, asking them that we have committed a blunder, we were not able to safeguard you people, so compensating them via the monetary benefits. Third happens to be rehabilitation. So what is this rehabilitation? Rehabilitation basically ensures that to restore a certain level of reputation and also provide legal mechanisms as well. What is this legal mechanism? So that in case their legal rights are violated, they would be represented by the advocates who would fight for them, and ultimately their rights would be restored. Then we have satisfaction. What is the satisfaction? Public apology. There has been a blunder that has been committed in the past, so we seek an apology. We have President Barack Obama, who has also sought public apology for Pearl Harbor. So for example, a leader from a community or in fact the state seeks a public apology so that it is leaving a sense of satisfaction to such people. And finally, guarantees of non-repetition, which means that such incidents will not occur in the near future, is what is this Truth and Reconciliation Commission. So if at all there has to be a sense of justice that has to be provided to the victims of crime that have been perpetrated in 1990s, these steps can be initiated as part of the Truth and Reconciliation Commission, is what is this article all about. Now let's look into the next article. This article says, carry on doctor. What is this article speaking about? The article here is speaking about medical negligence. I'm sorry. What is this medical negligence? What is this medical negligence all about? Let's say, for example, I have met with a road accident. There has been scratches. There is a lot of blood oozing out of my hands. So I go to a hospital. What should the doctors do? The doctors, with a minimal basic common sense and with the basic minimal parameters that have been established, they should be able to give such medicines. They should be able to operate as soon as possible. But what if they have given medicines against the normal practices? That is what is called as the medical negligence. So negligence comes whenever there is a parameter that has been prescribed by the medical fraternity, and if the medical fraternity is not able to meet this intended standard guidelines that have been prescribed, they have violated these. That is what is going to lead to medical negligence. Me being an advocate, I have seen couple of cases. I have also been part of number of cases of medical negligence. To give you an example, let's say for example, there has been a person who's gone through a fracture, which means there is a bone dislocation or there is a fracture. In that particular case, what should a doctor do? The doctor should basically understand and give what are the options that are available to the patients. For example, if there is a fracture in the lower limb, let's say a little finger in your feet, then what should the doctors do? The doctors should give options to the patients that we have. For example, if at all there is a fracture, there is a procedure called as the K-wire. There is a procedure called as the insertion of the plate. So if at all there are options that are provided, if at all there are a couple of options that are present, what should the doctor do? The doctor should give these options to the patients. It is the patients who should also be able to discuss with the doctor and ultimately see what is the best that they can fit in, and ultimately conclude that this is the best possible solution for the patient. The doctors would also be able to take a decision that this is the best possible decision, but a normal doctor should be able to follow the prescribed guidelines. If at all these guidelines are not followed, that is what is going to lead to medical negligence. Let me give you another example. Let's say, for example, a doctor has opened up a part of your body, operation is being conducted, a piece of cloth, a band-aid has been left in the stomach of a person. That is what is called as medical negligence. Or for example, the doctor should have given the injection to the spine, instead he is given the injection to the leg. That is a medical negligence. It will have likely side effects as well. This is what is medical negligence. And at the same time, let's say for example, a doctor is supposed to follow procedure one after the other. If at all the doctor has not followed these medical procedures that have been already established, that is generally followed by the doctors, that is what is going to lead to medical negligence. When it comes to medical negligence, there are two types. One is what is called as civil in nature. The other is what is called as criminal in nature. What is civil in nature? Whenever we speak about civil in nature, a certain level of damages will be taken up by the doctors, which means to say that I am a patient who's gone through a particular medical negligence. So what do? I go before the National Consumer Affairs Commission. I also go before the Medical Council as well, and I say them that this has been because of the negligence of the doctor. I was made to go through the surgery for the second time. So I seek a compensation, I seek a damage. This is civil in nature. So the doctors will have to pay a certain sum of money to me as a patient, which is civil in nature. And they also issue a warning to the doctor that you're not supposed to do it so and so, or they will also disqualify the doctor from practice for about 6 months or 1 year. This is civil in nature. So it means that a certain level of compensation will have to be paid by the doctors to the patient, one, or this person will be issued with a warning, or third, this person can be suspended from practice for about 6 months to 1 year. That is the general practice when it comes to the civil liability. What happens when it comes to the criminal liability? When it comes to the criminal liability, if at all there is a gross negligence in that particular case, the doctors may also be thrown behind bars as well. So what is the question? How do we understand what is gross medical negligence in terms of criminal liability? Gross negligence standard, it includes the court held that for a doctor to be held criminally liable, the negligence should be of such a high degree as to cause gross negligence. How do we understand what is gross negligence in terms of criminal liability? We have one of the landmark judgments delivered by the Supreme Court of India in Jacob Matthew versus the state of Punjab and another in the year 2005. So in this landmark judgment, they have said that there has to be gross negligence standard, intentional acts or omissions. You should have done a particular act, he has not done that particular act. You should have not committed a particular act, but he has committed such an act. Or the court emphasized the importance of adhering to high professional standards and medical ethics, and that a breach of these standards could be a ground of criminal liability. A certain parameters have to be followed, but this person, the doctor, has not followed, which has led to the death of that individual. So whenever we are speaking about criminal liability, if it leads to a death of that individual, that is what will be considered as criminal liability. The court also highlighted significance of obtaining expert opinion to establish negligence, and that opinion should be given by a doctor in the same field as the one being accused of. So if at all the person is being accused, the doctor is being accused, so whosoever is the person who is giving the expert opinion should be a senior to him, or it should be equivalent of that person. A junior doctor cannot provide an expert opinion. On the basis of this person will be decided whether he has committed a criminal offense or there is negligence or not. Why are we discussing about it? If at all you are following newspaper properly, the IPC will be replaced by the Bharatiya Nyaya Sanhita. So it has been passed in the Lok Sabha and also in the Rajya Sabha. When you look into the original Indian Penal Code, Section 304A of the Indian Penal Code, whoever causes the death of any person by doing any rash or negligent act not amounting to culpable homicide shall be punished with an imprisonment of either description for a term which may extend up to 2 years or with fine or with both. So earlier, if at all there was medical negligence executed by the doctor, these doctors were put under the criminal provisions and they were thrown behind bars, and the maximum extension for was about 2 years. So they would be thrown behind bars for about 2 years with fine or with both. But when you consider the Bharatiya Nyaya Samhita, originally when it was proposed, the penal provision was enforced for about 7 years. So whosoever is the doctor who is involved in medical negligence, criminal liability, he would be thrown behind bars for about 7 years. Subsequently, amendments were made and it was reduced to 5 years. Then we have the Indian Medical Association, which gave a representation, and after the medical representation, it has now been reduced to about 2 years as it was originally under the Indian Penal Code. So medical negligence is still punishable, but the imprisonment of either term for a description which may extend to 2 years and shall also be liable to fine as well. So the Indian Medical Association is happy because the BNS, which originally envisaged 7 years of imprisonment, is now reduced to about 2 years, so on and so forth. So this article goes on to say that yes, when it comes to the criminal intention, what is criminal intention? Intention in technical legal terms is called as mens rea. So if at all we are speaking about the medical fraternity, the medical fraternity in all likelihood does not want to kill the patient. So they do not have the mens rea, zero mens rea, which means they do not have the guilty mind, but because of the negligence, yes, 2 years of imprisonment is a necessity, but the mens rea is absent in this particular case. There is no guilty mind in this particular case. They do not want to kill that particular patient, but an act that they should have committed, or there is an omission. In that case, yes, there is negligence, which is why 2 years of imprisonment is imposed on such people, and it need not be 7 years or more, and that is what this article is all about. Now let's look into the next article. This article says Trump's insurrection role, legal impact. So this article here is speaking about the 14th Amendment. So what does this say? The Colorado Supreme Court said that the former President Donald Trump is disqualified from holding the presidency under the Constitution's so-called insurrection clause, and ordered the Secretary of State to exclude his name from the state's Republican presidential primary ballot. The landmark decision from the divided Colorado Supreme Court, Trump cannot hold public office under the Civil War era provision, is unprecedented. What is the Civil era provision? What we have is Section 3 of the 14th Amendment. So whenever we are speaking about United States of India, United States of America's Constitution, you have to know for the fact that they have amendments, that is their changes that they have incorporated in the Constitution of United States of America. According to the text of it, no person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state, who, having previously taken an oath as a member of Congress or as an officer of United States or as a member of state legislature, executive or judicial officer to support the Constitution of United States, shall have engaged in insurrection or rebellion against the same. So if at all there is a person who belongs to any of these categories, if he is pitting people against the state, asking people to take up arms against the Constitution, against the government established by the Constitution and the day, in that case they can be disqualified. They need not be allowed to contest the elections, and such an exemption can be given only by the Congress by a vote of 2/3 of each house remove such disability. So only if the Congress so decides, the Congress is the legislature in the United States of America, if at all they decide, an exemption can be given. Because Donald Trump back in the year 2021 had instigated the people, and you had people who went up to US Capitol, and as a result there was insurrection against the state, which ultimately led to this interpretation by the Colorado Supreme Court. And this basically means that in the state of Colorado we may have Donald Trump who may not be able to contest the elections. So in all likelihood he may go on an appeal, but as of now he would not be able to contest the elections in Colorado as per the Colorado Supreme Court. Now let's look into the next article. This article says railway officers to be trained in disaster management. We've seen number of disasters that strike the railway department as well as the railway ministry, and there have been couple of accidents which have been taking place in Andhra Pradesh, Odisha, so on and so forth. So as part of overall changes and in order to ensure that such disasters does not occur, what we have to do is provide training to the administrative personnel. So what the Ministry as Railways has done is, it is providing training to the disaster management mandatory for all the railway officers. The move comes in the investigation into the devastation of Odisha train. So the disaster management has now been incorporated as part of integral component of the training module for the railway officers, and at the same time it also includes refresher and mid-career training programs. The National Academy of Indian Railway Vadodara and the Indian Railway Institute of Disaster Management would work in imparting the comprehensive training program, said the railways. So for all those officers who are in the railway department and the railway ministry, they would be provided the required training. So this can be a fodder for your mains examination. It is this that we have to understand with respect to this article. So this is it for today. Thank you for watching. All the best.